Mr. Chairman, members of the committee, thank you so much for the opportunity to be here today. I take you back to the last week of the original Constitutional Convention in 1787. George Mason stood up on the floor of the convention and said that the current proposal that was in front of him at that time to only allow Congress to propose amendments to the Constitution would not work in the case where the federal government was abusing its power. And he said that the states need to have the ability to also propose amendments, or else we would never get amendments that would limit the power and jurisdiction of the federal government. And because he predicted that someday the government would abuse its power. And without debate, without dissent, the current version of Article 5 was passed as an amendment to the then Constitution, and it became final ultimately about a week later. And so we now have in front of us the history of Article 5. There have been 450 applications for a convention of the states on various topics. And by the way, if a state or any state passes more than one convention of the state application, they're independently counted. It has no effect on the other. And so whenever one of these topics gets to 34 states, then you have a convention on that topic, and the state can join more than one at any time, or two or three, or whatever it wants to do. They're completely independent. And so, but 450 applications have been passed in the history of their country. Most of those are still valid, but the reality is we've never gotten to 34 states, or 2/3 of whatever the number was at the time, 2/3 of the states on any particular topic. The agreement on the topic is like setting the agenda for a committee hearing. You have to agree on the topic ahead of time. And the decision on what the topic is binding throughout the process. And so the question before us all is George Mason's condition for having a convention, is it before us? Is the federal government abusing its authority? We can just look at a couple of factors regarding the bureaucracy. There's so much we could say that's abusive, but just focus on one really important area. We have 50 books of laws passed by the United States. We have 250 books of laws passed by the various agencies like the EPA and Department of Labor and so on. So we have 5 times as much law passed by people that are not elected by the voters as we do by people that are elected by the voters, despite the fact that Article 1, Section 1 says that all legislative authority is vested in the Congress of the United States. And we're learning in the recent weeks with the DOJ committee and so on that not only do they have essentially unchecked power, or rarely checked power, perhaps would be a little more precise, on their use of their legislative authority, their spending power is absolutely out of control. Nobody knows what they're doing with all this money. It's functionally a closely guarded secret. The ability of unelected bureaucrats to spend money at will and to pass law at will is not how a Republican form of government is supposed to work. Because whoever passes laws, whoever spends money is supposed to be accountable to the voters, and we should be able to vote the rascals out. We can't vote these rascals out that are doing this, and we need to fix the Supreme Court decisions that have ignored Article 1, Section 1, and the other articles relating to spending, so that we have fiscal restraints and we have political accountability for all these things. Now, one other generalized factor that mandates this without really much question is $36 trillion and growing rapidly in debt. And if we were to follow the general accounting principles for businesses, that number would probably be about 5 times that amount when you take all the amount that's been borrowed from the Social Security Trust Fund and so on. The amount of debt that the government has incurred is just unbelievable, and it's got to be stopped. The founders gave states the ability to stop it. They gave state legislatures the ultimate power to control what the federal government would do. And so the only question is, Will you accept the responsibility given to you by the founders to make sure that the federal government is accountable and is doing what it's supposed to do? It will not control itself. My wife and I have the blessing of having 10 kids. And so I think I can speak as a subject matter expert on kids to some degree. And I have a pretty good idea what would happen if you tried to raise a kid for 18 years and never discipline them. Well, we're seeing what happens when states let the federal government go undisciplined for approximately 250 years. That an undisciplined government is out of control. And it's time for the states to impose discipline. The only argument from that we usually encounter in states like Kansas is the possibility that this might run out of control. It's a myth that the original convention ran out of control. I've written a Harvard Journal of Law and Public Policy law review article showing that that is just a defamation against the Constitution. We can get copies of that law review article for anybody that wants it. But the short answer is it did not run away. They followed the rules that were set by the states. The states set the rules and they followed them. But moreover, with the 450 applications, we have a historic rule that the subject matter agreement is absolutely binding. And it's binding throughout the process, not just at the beginning of the process. You can't go outside the subject matter. And there's been litigation. I filed the very first case on this topic ever in the history of the country when I was a very young lawyer on the Equal Rights Amendment, when Congress tried to manipulate the process for ratifying the Equal Rights Amendment by changing this stated deadline of 7 years to add another 3.5 years. And that litigation was successful, and recent versions of that litigation have also been successful. We've found that you can't manipulate the process. You got to follow the rules that brought you to the table throughout the process, and that's been rehearsed and reinforced time and again with the ERA litigation. Finally, the fact that 38 states have to ratify, which means if 13 states vote no, one House and 13 states vote no, or 13 states don't even vote, you have to get affirmative votes from 38 states. And the ability to get something crazy through that process is just not realistic. Bills get filed all the time in Congress and in state legislatures that everybody in the world knows will never see the light of day. And the reason is they're crazy. And crazy stuff does get proposed, but crazy stuff ultimately does not happen when you require 38 states to ratify it. It's very difficult to do something good. It's impossible to do something crazy. And so with that, I'd be glad to answer any questions that you might have. And just thank you for the opportunity to be here remotely, Mr. Chairman, and members of the committee. It's an honor to be with you today.